And then now I'm working as an assistant professor of law at Seedling School of Law and Governance, Jaipur National University, Jaipur. So the topic for today's webinar is mooting skills and the how to prepare the memorial and how to take the participation in any of the moot court competition. All right. So first of all, it is very important to know that what is a moot court. See, in just a single word, moot court is a dummy court, right? So whatever proceedings an advocate faces once he enters in the field of litigation, so just in order to make those proceedings understand to a law student who has just entered the law school after completing the graduation, this moot court activity has been conducted by the various law schools in the country, right? Now the question is, like, who has started this practice of conducting the moot court competitions and the moot court at the intra level or at the college level? So I would like to tell you that Bar Council of India has given these points that every law school should be having the practice of conducting the research. That is why we have the research committee, or conducting the moot court competitions. So we have the moot court committees and the moot court societies respectively, right? Other than the academics for which a student who enters the law school, the other co-curricular activities which are very indispensable for the students to be taken up in the course of 5 years or 3 years, there are so many activities to be done. So out of them, we have the seminars, we have the conferences, though it is the pandemic time, and as you know that the inner conscience of each and everyone has been shaken in these days. So we are on the platform of the webinar. So it is like a workshop, it is a workshop only. So the other activities which a student can participate into are like seminars, the conferences, or you can participate in the training and the training courses and the certificate programs, which is of usually of 3 days to 6 days. And you can write research papers also. You can take participation into the roundtable colloquiums. And most importantly, this moot court, because when you are pursuing law, so you are about to become the budding lawyer, or I would say a fancy word, hotshot lawyer, right? So, and plus the internships also, which you are supposed to do in every year, be it a NGO or a sessions court or a high court, Supreme Court, so on and so forth, right? So moot court, why it is important, I'll be sharing a PPT with you just for a backgrounder of this topic. Then after that, I'll take you to a memorial where I'll be telling you that how it has to be done. Am I audible and clear to you people?
Yes, sir, you're audible.
Okay. Can you see the PPT on the screen?
Yes, it's perfectly visible.
All right. So here I would like to start this webinar with these two quotations. The first is given by the Roscoe Pound, that the law is experience that is developed by reason and applied continually to further experience. So basically, law, as we say in the layman language, is a common sense, right? So whatever reason we have, whatever reason our legal mind and legal intellect has developed, right, that is coming by the way of the experience, or better you say it is a vice versa process, that whatever you are experience you are gaining, so there is a reason behind that. There is a reason that you have joined the particular law school, so that you want to pursue this, so that you would be in a position to become a good lawyer or a good judge or a good academician, right? So law is an experience that is developed by the reason and applied continually. It is a continuous process for gaining the further experience. All right. Next quote which I would like to tell you is that a moot is a fox theater. Here the meaning of the word fox is, I would not say fake. I mean, the literal interpretation of this word is fake, but otherwise fox is duplicate, you can say. So as I have told you, it is a dummy quote. So moot is a dummy theater of war. War in the sense that you people are practicing before the honorable court where the judges are sitting and they are judging you, and you have put your question of law before them. So they'll be judging you. So a moot is a fox theater of war that trains you. That is a training which you are getting, that trains you for the real life cut and thrust of court, right? So this particular activity or this particular you can say session, I mean, of the moot court, that would allow you to sharpen your legal acumen, your legal skills, your research skills, and obviously it will boost up your confidence in the particular court of law. All right. Am I clear to you, people?
Yes, sir, you're absolutely clear.
Okay. So now the question is, what is mooting? So as you can see in the screen, I'll be just taking up the keywords that it is the oral presentation, right? Of a what? Of a legal issue. Now, legal issue involved in a particular case, that is the controversy in a case. Whenever you are getting a moot problem, either it is a subject moot problem of the law school or in any of the national or international moot court competition you are participating, so you have to adjudge and you have to ascertain that what is the actual controversy involved in that particular case on which you have to work upon accordingly. So the oral presentation of a legal issue or problem, one of the similar things, against an opposite counsel. An opposing counsel, obviously there are two parties, right? X and Y, you can say in a layman language, and that activity is happening before a judge. It is perhaps the closest experience which a law student is getting, so that a student can have whilst at university to appearing in a court. When you are in a law school, so you are allowed to go for the internships and all, but you are not allowed to practice before the court, because for that you have to clear the All India Bar examination once you are graduated, right? So what you can do internships, and you can other than internships you can participate in such moot court competitions, right? Just to take the flavor of what is actually happening before the courts. And in the internships, you can see how the judges are participating and how that particular area is surrounded by the number of laws, be it national or to an extent international in India, and how the activities are going on. So it is perhaps the closest experience that a student can have whilst at university to appearing in court. The next question, why should I get involved in mooting? Being a student, suppose I am a student of first year, right? So first of all, if the student from the first years are present here, you should participate. I always suggest you to participate, but at least know the law first. There is no hurry. You have a good number of years in this law school to participate in such activities. So even if you are in first year, at least be well versed with the law, the national laws like IPC, CRPC, CPC, and evidence in the constitution. So it also depends on the moot court competition in which you are participating, because there is no as such field. It can be on criminal law also, it can be the international law also, it can be upon IPR also, environment law, and if it is on international law, the ambit is very open. See, it can be on the investment, BIT, the Model Bilateral Investment Treaty, or it can be upon the banking laws, so on and so forth. So why should I get involved in mooting? It is forming the compulsory part of the certain law courses, and most of the law schools in the country, it is a compulsory practice, and it is a very important co-curricular activity or the exercise at your law school. Plus increasing demand of legal profession. Why it is why the demand is increasing? Because as the law is dynamic, it cannot be static. So there are changes which is happening each and every day. If you people have the practice of reading the live law or the bar and bench, you can see that how the Supreme Court, the Honorable Supreme Court, is passing the judgments on the various issues of laws. Why it is happening when the statute or the code is already written? But why it is happening? It is happening because the law is evolving. The law which is already written is there. We have to follow that. But as per the time, as per the changes, and as per the circumstances, we have to evolve the particular law. So that is how the demand of this particular profession increases. And when the demand increases, we would be needing the lawyers who can really brief the matters quickly in a short time, and that is how you can save the time of the court, and that is how the the justice can be delivered very fastly. So it is not up. Let me tell you one fact also. that it is not up to the judges only to avoid or prevent the process of delaying in the justice. It is up to the advocates also, that how they are practicing, how they are taking the conventions, whether they are taking the convention, I mean the practice of the court, seriously or not. It is up to them also. So the increasing demand of the legal profession has to be sharpened, and that sharpness will come from this stage only, when you are at the law school. Plus it will help you to build the confidence in the public speaking. So when you are at the school, or when you are going outside for any of the debate, it is not of the mooting only. If you are participating in the parliamentary debate, British parliamentary debate, you are participating, suppose, or you are a part of a roundtable colloquium, a big table is there, all the participants are sitting over there, and then you have to participate whenever your time is coming, when your turn is coming. So on the issue pertaining to, you can say, supposedly CEDAW, or issue supposedly upon the golden triangle, right? So you have to spontaneously speak upon that. So public speaking is also an integral part of the curriculum, which one needs to take care. Plus journal research, the research which you are doing today, by keeping in mind all those research platforms, be it Manupatra, be it SCC online, right? Or people, they usually use Indian Kanun also, but most preferable is Manupatra and SCC online, because the information is more. I would not say that Indian Kanun is less credible, but the thing is that SCC online will be having the issues, and it will be having the things in a confined and refined manner. So your research will be what? Your research will be quick. So after the 5 years, when you are joining any of the law firm and you have been assigned a task to draft a PIL, public interest litigation, or an SLP, and you are good at research, being a mooter at in the previous years of your law school, you will be in a better position to complete your work on time, and that is how you can save both the things: the justice dispensation part, the time part, and whatever compensation you are getting from that. Plus presentation skills. In the world of the competition, when there are n number of people being a part of this particular field, so you have to be a bit divergent. I mean, not divergent, you have to be a bit unique. So just to make yourself unique and different from others, your skills has to be very, very, I mean, different and unique, and it should define in a proper manner what you are conveying to the particular person sitting in front of you, that is a judge. Most importantly, the point, the other point in this is building your CV, your curriculum vitae. Start after from the first semester. I'm not telling you to participate in any of these competition from the first semester, but even if you have started writing the essay from the first semester, so that particular point can be added in your profile, right? That is your CV. So at the initial level of the college and the law school days, your CV is your profile. The activities such as the essay competition, or in any of the seminar you are participating, and even if you are participating in any of the moot court competitions, supposedly on the online platform, that will definitely add into your CV, where it will help you once you will be graduated. Your esteemed law school will be helping you for getting the suitable place for you for the job purposes, or else you will be interning in the last years of your law school in any of the firm, where when you have shown the capacity of yours, that how efficient you are for the organization, and the organization is interested to take you, so there, that is a process called PPO, pre-placement offer. So your efficiency and your skills and your behavior, everything will be seen, and everything will be judged, and that is how you will get a place to work in, right? So such activities like the moot court, and if they are in good numbers in your CV, so that will help you in the corporate sector. That will help you in the litigation sector too, in the litigation firms. So Corporate sector is a different thing, litigation firm is a different thing, and litigation chamber is a different thing. Litigation chamber is purely working upon the cases which they have designed for themselves, the laws which they are specialized, in which they are specialized. Litigation firm, when we talk about a litigation firm, so there they have opened their ambit and they have called up so many people who are working with them, associated with them, and they are working upon the different laws as and when the time required. So for the cases of IPR, they have a different lawyer. For the cases of corporate, they have a different lawyer. For the cases of admiralty, that is the law of sea cases, right? They have a different lawyer. So building your profile in the initial days of the law school will be a good chance for you to get more cases, or I would say a chance to get connected with more people, right? So that is how you can create your own link, and that has to be done by you only. All right, moving ahead, how it is to be done. First of all, whenever you get a problem, obviously the moot proposition, right? So there is a problem. So a moot problem is concerned solely with a point or points of law. These points of law is the actual controversy in the case. This is a backgrounder or a general thing which I am telling you right now. So after the problem has been adjudged, the second thing is the teams, right? So it is usually comprises of the two speakers when you are participating outside the school, and one researcher, right? And one researcher, right? So mooters may be judged individually or as a team, both, right? It is upon the judge. Third thing, the moot court should reflect as far as possible. This is for the school purposes. The moot court, this third point, basically, the moot court should reflect as far as possible a courtroom scenario, right? Being a dummy court, a scenario which looks like a reality to a student, so that the hesitation of the student would be removed. Whenever that particular student is going outside for the competition, he should not be hesitant. He should be confident, whatever law points he has raised, because judges would definitely try to drag you into a position where you will be bombarded with n number of questions and you will be confused. And if you are prepared on a particular point of law, right, supposedly golden triangle, and the judges are asking you about the the notable judgments on this particular topic, and you are citing the judgment, and the judge is asking you that no, this is not the particular case, and now there you are confused, you are lacking the point, you are losing the marks, right? So in that case, just to in order to avoid that, that reality scene has to be created in the courtroom to remove the hesitation, right? You practice this speaking area more and more whenever you are at home also, right? In the front of the mirror, you start speaking. You start speaking upon the facts. You start speaking about the case laws which you are about to cite in your problem, right? What is the jurisdiction which that I'll be covering in the next slide? What is the jurisdiction which you have, for which you are appearing before the particular forum or the particular court? So all such points you need to discuss with yourself when you are standing in front of the mirror. The common point that the moot is presided over by at least two judges who delivers a judgment at the end. Delivering the judgment at the end doesn't mean that they are writing the actual judgment. That means they are putting upon their points what they have understood from this, and if any of the suggestion which they are they believe that it is indispensable for the participants. So that particular suggestion after the rounds which is given by the judges, that is a delivering of the judgment at this point in this point, right? So further, so while preparing for a moot, you have to first of all identify the grounds, right? That is your controversy, that the mooter should first read the problem carefully in order to ascertain the precise grounds. The grounds are usually stated in the body of the problem which you are getting. Conducting research, it may sound obvious, but ensure from start that you and your moot partner, in the case of the outside competition, you have to be well versed with the sides which you are arguing, just to avoid any kind of discrepancy at the stage of the argument, because that will tend to lose your marks in front of the other team, right? So the parties, it can be appellant or the respondent, right? lastly, the structure and presenting the argument, right? So with a view of this argument which you are presenting before the judge, so that you have to decide that what you are expected to persuade the judge to accept. It has to be very conclusive, the fact and the law. Plus, you must now work out how your argument is to progress to that conclusion. So all such things is a part of your preparation, which you will be doing. Now, what is the objective? Objective is to hone the legal skills, your research, right? Research upon a particular problem, keeping in mind the laws, your writing, that is the problem, that is a memorial, memorandum or a memoranda, or the piece of literature which you are preparing, your case file, you can say, which you are preparing for the presentation, your presentation in the reality, which you will be doing, your argumentative skills, your mannerism, your manners in the court, your teamwork, and the compatibility. So all such things are there to develop the legal acumen, right? So your legal skills and your legal acumen, that blend has to be, that particular blend has to be followed, and it has to be balanced in a way to provide the justice to the party for which you are appearing, right? Now I have, this is the last slide in which I have defined, tried to define in an elaborative manner the points which has been raised in the objective. That research, why the research has to be done? Just to underline the philosophy. Research is done from the philosophy of the law. Philosophy is not the subject which I am quoting here. I mean the idea, the purpose and the essence of that particular law for which it has been incorporated. That philosophy you can derive from an example, that the principles of the law is talking about that there should be justice, there should be equity, there should be good conscience. So justice, equity, good conscience, right? When these three terms crisscrosses the idea of non-arbitrariness, non-fancifulness, non-oppressiveness, right? It forms the part of a particular principle which is protecting and guiding the people at large. We are the people of India, we are governed by the constitution, that holy document, we are governed by that. So when we are talking about the philosophy, when you are researching about a point, just a small example, Article 21 of the Constitution of India is saying that no person shall be deprived of his life and personal liberty except according to the procedure established by law. So except according to the procedure established by law, this particular line is what? This is CRPC. The procedure established by law is CRPC. So that is how you have to derive the philosophy of a particular subject when you are researching for the Moot problem. Right? This was why. Now, what is how? How is the methodology? Which research you are doing? What sort of a research you are doing? The interpretation which you are doing, the principle, the hidden principle, whether you are doing the purposive interpretation, right? Whether you are following the harmonious construction, all such research things has to be taken care of. All right. And then where is the answer to this is the sources, right? Sources means the primary sources and the secondary sources. Obviously, the primary sources are always your books, your textbooks. And the secondary sources are the internet materials which are available with you. It can be the law journals also, to an extent. It can be the articles which are written and published online. It can be a part of the newspaper also. It can be something which is written on a caricature, right? So these are the sources which you have to follow while doing the research. When it comes to writing, you have to take care about the objective of your particular research proposition, the style in which you are making the memorials, right? I mean, style includes, it is a subset of the formatting only, that it has to be formatted in a way that the rules which are mentioned in the proposition and in the brochure of the competition, it should not frustrate the what you are formatting. So the formatting has to be properly done. So in that case, you have to follow the rules. It should be defined. It should be streamlined in a proper manner. When it comes to presentation, that includes the court etiquettes, your attire, your body language, your argumentation, also everything. When it comes to argumentation, then you have to identify the issues, because court can stop you there and then if your issues are not properly and well framed. The use of the authorities, it includes the sources also, it includes the statutes and the codes also which you are referring into. And most importantly, the case law, the precedents which you are mentioning, just to support the facts which are there in your moot proposition, which are there in your memorandum. When you are mentioning the case law, you have to be very well versed with the fact that judge can at any point in time may ask you whether the points mentioned by you in a particular case is a ratio or an arbiter. The difference between two is very simple. Ratio is talking about the legal point on which the entire judgment is based, right? So these are the important legal indispensable points on which the judgment has been passed, right? So the main legal points, and the obiter dicta is the observation by the honorable court, right? Moving ahead is the mannerism, that your style, again, how you are dressed up, how you are behaving before the court, your posture in which you are standing, you should be straight. You should not show fingers to the judges. If the judges are not satisfied in any point of law with you, argue, but argue in a way which is prescribed, right? If the judges is not satisfied with a point, then you can say that, all right, apologies, your lordship, I'll try to improve this point, and I believe the points which I have raised is appropriate according to my proposition. All right. And the demeanor. Moving ahead, the most important thing is the teamwork which you are doing, that the compatibility has to be there. All right. So that you will not any chance in the competition for the purposes of, you should not leave any scope of winning. So that compatibility has to be there between the researchers and the speakers. If the speaker is missing any of the point, right? So researcher can pass on the chit to the particular speaker, right? That can be done. Plus the networking which you are gaining from there, the networking at the law school level, as I've already told you earlier also, that this networking would help you in getting the more opportunities in the upcoming years, and obviously after the graduation from the law school. I hope I was audible to you people.
Yes, sir, you were audible.
Okay. Apurama, how much time do we have, if I may ask?
Sir, since there is no restriction.
Sir,
Yes, please, sir. So, sir.
Sorry?
20 minutes we have.
Okay. Thank you. Is it visible to you people, this memorial?
Sir, I believe the memorial is invisible. We are able to see this thank you everyone slide right now.
Sorry, can you see it?
Sir, actually, I was saying that I don't think that the memorial is visible to us. It's just the thank you slide that we're viewing earlier. It's just that we are able to see, not the memorial.
Okay, just a minute. Is it visible to you now?
Yes, sir, it is visible
Yes,
now.
sir.
Okay, okay. So this is a sample memorial for you people, all right? This is the first page of the memorial, all right? So you have to follow the rules of the competition. If it is written on a brochure that you have to mention the, the name of the competition, then obviously you have to mention along with the logo of that particular law school which is organizing this event, right? Then you have to follow with the team code, all right? Moving ahead, this is before the honorable court where you have to file the case and where you are appearing for the moot purpose, right? So, and sometimes it is written in the problem that the laws of the, supposedly Hindustan is written over here, the laws of the Hindustan are peri materia to the laws of the India. So peri materia, whenever this particular word is used, that is the same subject matter or similar, right? So Hindustan and India, the laws of the Hindustan and India are similar, all right? So here we are approaching the Honorable Apex Court or the Honorable Supreme Court of India. The name of the parties are mentioned over here, the petitioners and the respondent, right? This petitioner can be the applicant also. So whenever we are filing the suit for the in the court of the first instance, it can be applicant, right? Or whenever we are approaching the court for the SLP or the PIL or the writ petition, so party can be petitioner. And if the matter is at the appellate stage, so party could be your appellant also. So it depends upon the moot proposition also, that where you are taking the case and what sort of a matter it is. So it could be petitioner also, and your appellant also, applicant also, all right? So here Mool Nivasi cause and another, this is the name of the party, and this is the other petitioner, and then Union of Hindustan, they are the respondent. Then you have to mention the case concerning, what is the case is related about. This particular memorial was a part of the 2015-16, all right, and it was on the topic of the right to privacy, which has been settled now by the Honorable Supreme Court of India. Earlier it was not that settled, but now it has been completely settled by the Honorable Supreme Court of India, and the judgment has been passed by Honorable Justice Chandrachud, all right? So you have to write the title, that the case, the matter is concerning to what issue. Then it is the memorandum on behalf of the petitioners or the respondent. This was the first page. I hope it is, I'm not going fast.
No, not at all, sir. The speed is actually okay for us to understand.
Then this is the table of content in front of you. As you can see, table of contents can be made in two forms, right? One is the manual and other is the automatic, right? So due to the paucity of time, I won't be able to in a position to to show you how it is to be done. But here you can see that it is done automatically, right? So when you do it automatically, so things are streamlined in a proper way, alphabetically, right? And the spacing and formatting is done accordingly. So though it is very easy to do with the manual this table of content thing, but rather than going for that, you should opt for the automatic one. So table of contents, right? So here we are following the index of authorities. All right. Here it is. Just a minute. Index of authorities. Then your statutes referred, right? Index of authorities includes the statutes, the codes, the acts, you can say, the cases, right? Now these will be bifurcated further also. The books, the primary sources which we are mentioning, the statement of jurisdiction, right? The facts, the statement of facts, the statement of issues, which in the table of contents you are supposed to mention here also, the statement of issues. All right. I'm showing it again to you. The table of contents, including the index of authorities. The subsets are statutes, the cases referred, the books referred, then the statement of the jurisdiction, then the facts, then the statement of issues, the issues which are mentioned over here, what issues we are taking. I'm just not reading completely, but I am here talking about the public interest policies which are affecting the individual rights, right? And whether they are in line or whether they are not in line, whether they are amenable to judicial review under Article 32. And here we are talking about the concept of non-leakage. Non-leakage is a term which is the international concept, right? It is basically talking about the silence of law or absence of law at a particular place. It is not an Indian concept, though we are practicing and we are appearing before the Honorable Supreme Court of India. But you can also do it that whenever you are framing your issues, you can mention the you can take the international terms just to balance the particular issue which you are mentioning. That is how you can make your law points more stronger. So here we are talking about the non-leakage situation, which is more prevalent in United Kingdom, being a part of the Commonwealth country, vis-a-vis the right to privacy in India, right? So there the situation has been balanced. We are trying to do the comparative study also. Moving ahead, whether this government can ensure the protection of the particular privacy sensitive data. Anyways, moving ahead, now we are mentioning the summary, right? So summary is also including the points which will be which would be dealt in the later pages. Moving ahead are the arguments advanced, right? And lastly, the prayer, or you can say the submissions before the court, or you can say the relief sought. So all these three terms, they'll be clear. It will be clearly mentioned in your brochure that what you have to write in your memorandum. It is a prayer, or it is a submission before the court, or it is the relief sought before a particular forum. Now, index of authorities. Here are the statutes referred, right? Broadly, we have used the International Convention on the Civil and the Political Rights, right? In International Covenant on ICESCR, right? You can segregate these also. These statutes you can segregate, right? Like 1 and 2 point can be segregated, and the point third can be segregated into the Indian laws. So the Constitution of Hindustan, 1950. All right. Now the cases, it is very important for you to segregate the cases also. If it is an English case, that means a foreign case, write them separately. And if the case belongs to the India, write them separately. All right. So that is how you will be able to distinguish the matters before the honorable court whenever the judge is asking you that from which authority and from which source you are mentioning this particular point. So the foreign cases has to be mentioned in line. As you can see, they are also mentioned alphabetically. All right. Now we are mentioning the Indian cases along with the page numbers. So whenever you are doing the automatic formatting in this memorial while making the table of contents, so this numbering will be done according to the case which has been mentioned on that particular page, right? As Ahmedabad St. Xavier case is on the page number 29. But since this case is starting from the letter A, so it is alphabetically mentioned, but it is given on page number 29. So when you do the automatic formatting of the table of content, this will be done accordingly. So there you need not to work more or upon the making of the memorial on this part. All such cases are mentioned over here. Now comes the books referred, right? Since these are the primary sources, so the particular way and the particular pattern has to be followed, which is already defined. And if it is not defined in the brochure, you have to mention the title of the book first, like the administrative law, then the edition, right? Then the author, all right? And then the press. That this administrative law book has been written by the HWR Wade and CF, and this is the 10th edition, which we had followed in 2015-16, and it has been published by the University Oxford University Press. So for the books referred, you have to follow this format: the name of the book, the author, and the edition, the author, and the particular press which has released this text. Now comes the most important part, that is the jurisdiction. So broadly, the jurisdiction are divided into three parts. that is the subject matter jurisdiction, that is the territorial jurisdiction, that is the pecuniary jurisdiction. So that also depends upon the matter which is before you, right? So according to that, according to the situation, according to the circumstances, according to the controversy, you have to adjudge the jurisdiction. In the simple layman language, jurisdiction is the kshetradhikar, whether that particular court has the authority to allow you to present your case before them. So that has to be very, very important. That has to be taken care of very importantly. So in our matter, we are approaching the Honorable Supreme Court of India via Article 32, right? And now we have clubbed this with Article 142. Let me tell you, people, you can also do this. If you will read the Article 142 of the Constitution of India, so usually the mooters and usually the advocates also, they do not have this practice. Advocates to usually mention this particular article for the purposes of the arguments. But when you are a mooter, when you are doing mooting, so you can mention this in the jurisdiction part to enhance and just to support your existing jurisdiction. Article 142 is talking about the complete justice. So whenever the party is at the grave miscarriage of justice, so just to protect itself before the wings of the Honorable Supreme Court, or you can say the Latin term that Supreme Court as the sentinel on the queue vive, that is Supreme Court as the supreme authority has the power to protect the rights and freedoms of the individual, which it is already protected by the Constitution. So Article 142 per se you can use just to appreciate and support of the jurisdiction which you are using, right? Moving ahead are the facts. Since it is an old memorial, so what you can do, see, these facts has been mentioned in how many pages? More than 3-4 pages, right? What you people can do, you can write the facts in just one page, right? What are the cause of action? If it is a criminal case, the cause of action, the important dates, right? The parties involved. I mean, what the parties has told about the particular matter in that particular moot proposition. So you better do what? To make the facts in one page. That will help you in saving the time of the court also, and in the opening statement also, which the petitioner is giving at the time of the starting of the oral rounds, right? These are the statement of issues, right? So what happens in the issues is that you just mention issues in a single point. Like if you have 4 issues, so whether so and so is amenable to so and so, whether this court has a jurisdiction of so and so. But here we have made the sub issues also, so that also can be done. That under the issue of the public interest policies, we are mentioning about the scope of judicial review, just to open our argument. In the concept of non-leakage, we are mentioning the Constituent Assembly debates. We are mentioning the debates in the US and UK. We are talking about the standing committee reports and the replies to the government. We are talking about the current legislative efforts and the argument about the aforesaid sub-issues, which is the closing statement for all the above documents which we are mentioning. These documents are not mentioned in this memorial. So when you are going for the competition, you will be taking the compendium with you. Compendium is that bunch of or a particular book, you can say, or that bunch which is including all the extra miscellaneous documents which you are putting into. These can be articles also. These can be newspaper cuttings also. These can be the other sources also. These can be the judgments which you are mentioning in the Moot memorial, which you are just mentioning the main point of the judgment, just to support the fact you are mentioning in the arguments advance coming at the further stage, but just to support the source that from where you have taken. What you will do, you will take that particular case from the website of the Supreme Court of India, right? You'll go to the page of the Supreme Court of India. You'll mention the name of the, either you will be searching it by the name of the judge, or you will be searching it by the name of the year, or by the name of the case. You will get the complete text. Download that particular PDF file from that, right? Take a printout first. Before taking the printout, what you can do, you have to see that on which page number. Suppose if a judgment is of 45 pages, right, and you have mentioned more than 100 cases in your memorial. So, and for the all the 100 cases, you can't take the judgments of all the cases. And even if you are taking it, you are not supposed to take the entire judgment in the compendium. You are supposed to just take the particular paragraph. You have to highlight the particular paragraph on the page on which it is mentioned in the judgment. Highlight that page. Suppose that particular paragraph which you are mentioning in the arguments, it, right? So that particular paragraph is given on page number 96 of the judgment, right? So what you can do, you can take the printout of the first page, you can take out the printout of the last page, because the sign of the judges are there, and the particular page from where that particular paragraph has been taken, that is page number 96. So for a single judgment, for a single paragraph, 3 pages has been taken. That is how you can save obviously the paper also, and there is no requirement as such to take the printout of the entire judgment. First page, last page, and the page on which the paragraph has been mentioned, which is there in your Moot memorial, right? And these like these Constituent Assembly debates which I have mentioned on this statement of issues, the debates in US and UK, all such documents will be going in the compendium. Then the government can ensure the data on all such sub-issues, all right? Then comes the summary of pleadings. These are the, you can say, in the actual practice, these are your brief points. Whenever you are appearing before the honorable judge with your senior, and your senior is arguing, and he'll be needing a point, suppose on any of the law which he is skipping at the time of the argument, right? But you have mentioned that point in your brief. So that brief, including the dates, that brief including the main law points and the main law cases for the support of the law points, has to be shown to the judge at that point in time. And if it is not shown to the judge, in the normal practice also, I'm telling you, whether it is a High Court or Supreme Court, so even if it is not shown to the judge, you can tell the particular judge that this is the point on which I wanted to argue before you, but I skipped this particular point, right? For an example, you can talk about the Act of Makoka, right? Makoka is an act which has passed in 2002. This is the Maharashtra Control of Organized Crime Act, 2002. This act being the act of the Maharashtra, having giving the power to the Director General of Police in terms of arresting any of the gangster, right, who is belongs to the Indian territory and going outside the territory of India, and when coming to India and committing any crime, and even if not committing crime, he should be arrested. So DGP has been given powers under the Makoka. DGP, being the head of the state of that particular head of the police of that particular state, has been given powers under Makoka. Now Makoka is applicable in Maharashtra, but there are some cases which are telling that Makoka is applicable on Delhi also, right? And that advocate is missing this point to be mentioned before the honorable judge at Supreme Court. So your brief, if it is mentioning the points, the summary of what you are planning to plead, that can be told to the judge at that point in time. So this is the relevance of the summary of pleadings in terms of the real life court proceedings. The summary includes what we are mentioning further in the details. The summary is mentioning some of the points in this, on this page, the issue and the summarized version, 2 paragraphs or 2.5 paragraphs, that's all. Now, the heading of this is the arguments supported by the authorities, right? This is another way of writing. You can write the arguments advanced also, right? Or you can simply write the arguments in continuation. But these are the arguments which are supported by the authorities. I am just stopping here. So as you can see, This is the first issue, right? Here, the first line that the debate relating to right to privacy started or paved its way through the seminal piece published in Harvard Law Review in the year 1989. So whenever you are starting your first issue, you can mention the point which can be related to the genesis or the historical development or the historical evolvement. That is how you can make your memorial more unique. That the issue of the right to privacy, which has been settled down by the Supreme Court, paved its way for the first time in 1989. If you can see in the memorial footnote number 4, the second line, right? I am going to the footnote number 4. Here it is mentioning the link of this particular article. This was published in Illinois, right, in 1989. So that is how you can start your arguments in the arguments advance. And further on the arguments on the law point which we are mentioning, you can see the footnotes also, the articles which has been taken, since we have taken up the international conventions also in this in order to appreciate the right to privacy, because right to privacy is nothing has nothing to be done with India. It has evolved from the that particular foreign country in 1989. Here we appreciated this particular idea of right to privacy because it is now a fundamental right, but earlier it was decided in 1989 only. So we have mentioned the, on footnote number 5, we have mentioned the article of Lauterpat, right? Jurist like Elihu Lauterpat or Hirsch Lauterpat, right? The Victorian tradition in international law, right? Then further, so basically cases, your articles, right? And even if the article you're defining, all such things can be mentioned in your footnote, right? Then this sub issue is defined here, right? Here we are mentioning about the Article 21 in post-Menaka era, right? Supported by the Menaka Gandhi versus Union of Hindustan case. Now here you can see, here we have mentioned Menaka Gandhi versus Union of Hindustan and another. See, since the laws of this particular country is in perimeteria to India, so you can write both. You can write Hindustan also, you can write India also. There is no case like Union of Hindustan, but since it is in perimeteria, so you can mention Hindustan, right? Then this is the another article, 1890. This is written by the Samuel Warren and Louis D. Brandeis, The Right to Privacy, Harvard Law Review, 1890. So the hard copy of this is mentioned and given in the compendium, and the article, the idea of this article on footnote number 28 is given over here. That what it is saying, that the privacy have become more essential to the individual, but modern enterprise and so on and so forth, right? And how it is inflicted by merely bodily injury. All right. So this will go like this only. Then the second issue, non-leakage. So non-leakage is supported by some case laws of the foreign territory and one Indian case law also. Here, this footnote seems to be very long to you people, but that is how it has to be done, and with the entire link, right? Are you people able to follow?
Yes, absolutely, sir.
Yes, sir.
Who need to ask this question, but yeah. So these are the Constituent Assembly debates, right? Here is the footnote. B. Shiva Rao, framing of Indian Constitution. This is the commentary from where this particular paragraph has been taken to support the argument, right? What the committee has suggested for this particular case. Now the subcommittee on the fundamental right. So the main text has been photostated, xeroxed, and given in the compendium, and this is the argument which we are pleading in the court, that we, referring to this point as a part of precedent already decided, and we are requiring the relief according to these points mentioned. The debates in US and UK, this is a comparative study by Mr. David and Davis. So this will go like this only. Now I'm coming to the prayer directly. This is the last issue, whether the government can ensure the protection of the privacy sensitive data, right? So their IT Act has been mentioned, and the other connotations has been given as to what extent the government should ensure the protection of privacy sensitive data, right? So there are some articles, there are some cases, there are the text taken from the commentaries and our own arguments in terms of the judicial review and judicial activism, how they are broadly connected with each other, right? The role of the Supreme Court of India in protection of privacy sensitive data. When you are talking about the role of the Supreme Court of India in the protection of privacy sensitive data, so here you are mentioning about the power of the Supreme Court has the guardian of that, like the Supreme Court of India has the guardian of the fundamental right as the guardian, not the as the guardian. It is the duty of the Supreme Court to invoke Article 142 and issue direction to the legislature for protection of data to the citizen of Hindustan. That is why we have mentioned this particular article in the jurisdiction, right? This is the last page of the memorial, which is the prayer. Here you will be mentioning the wherefore in the light of the facts and the circumstances of the case, right? Issues raised by you, arguments advanced, and the authorities cited. Counsel for the petitioners humbly prays to the Honorable Court before which you are appearing to grant and declare the following. So and so are the points, or pass any other order it deems fit in the interest of justice, equity, and good conscience, the basic principles of the law, right? And for this particular act of kindness, the counsel for the petitioner shall be forever obliged and grateful, right? So this was the memorial which I wanted to share with you. Just one fact, and then we will conclude this, that this right to privacy judgment which has been passed by the Honorable Supreme Court, Honorable Justice D.Y. Chandrachud. So if you people, you must be aware about the case of ADM Japalpur versus Shivkant Shukla. So the dissenting opinion of the Justice H.R. Khanna, right, the doyen of constitutional law, the dissenting opinion of Justice H.R. Khanna in the case of ADM Jamalpur, the same facts has been reiterated by the Honorable Supreme Court of India in case Puttaswamy versus Union of India, right? So the right to privacy case is well celebrated in the name of the case Puttaswamy versus Union of India, and now it is a fundamental right. I am done with this. Akansha.
Thank you so much.
Okay.
Yeah. Thank you so much, sir, for providing us with such of a lot of information, and I'm sure our students must have learned a lot from you. And with this, I would just request the students, if they have any questions, then they can ask.
Sure.
The floor is open for their questions. We would just wait for another 2 minutes if someone has their question.
Sure.
If anyone want to ask any question, just raise your hand.
Parents, there is a request from a student that the memorial which you just showed us during the presentation, can you please send us to some of the faculty so that our students can take a reference?
Sure, definitely I will do that, along with some other reading materials also relevant for the students.
Thank you so much. Yeah. Thank you so much. Okay, I believe we do not have any questions from the students. So, moving on forward. As any event is incomplete without thanking everyone who indulged themselves to make this workshop a convenient one. So here I welcome Mr. Gaurav Sasar to deliver word of thanks, please.
Okay, thank you, Apurva. And I, Mr. Gaurav Shah, Assistant Professor of JEMTEC School of Law. So I'm indeed very happy to share the vote of thanks for today's seminar. And I would like to thank Mr. Paraj Aneja sir for, from the deep of my heart, for such a great webinar. And I'm 100% sure that our dear students inculcated lots of skill regarding the moot court competition. And I would like to thank once again for explaining in such a beautiful manner, in such a beautiful way, and making it easier for our students to understand the facets of the moot court in a very easy sense. So thank you very much, sir. And lastly, I would like to thank all the students for participating in the webinar, and also the Moot Court Society for conducting such a wonderful workshop in such a small amount of time. Thanks to all the faculty members for their technical supports, and thanks to you, Apurva, for your hosting this event. Thank you very much. So I hope someone has some question, so you can address that question from that student. Thank you. Thank you, everyone.
Thank you so much, sir. Um, I guess we do not have any questions from the students. So, moving on forward, I would like to mention that there is a link provided in the chat box for the students. That is the link for feedback form. So, every student present here in this workshop is requested to fill that feedback form, please. So, whenever we are done with this workshop, please fill that feedback form regarding this particular workshop. Moving forward, I would also request everyone, the faculty, the students, and everyone who is present in this meeting to please switch on their cameras for a group photograph. All the faculties and students are requested to please switch on their cameras for a group photograph. Thank you so much, ma'am. Thank you so much, everyone, for cooperating with us and being such an attentive participant and a member of this meeting. Thank you so much, everyone. With this, we have come to an end of this webinar. Thank you so much, everyone, again for joining.